hearing was to take place soon. And it says that you snippily told me that he would not even try to call the PO, I assume that's probation officer, on such short notice after I suggested he could at least try to reach out, and then you might get lucky and catch him. Is that true?
No, Senator, it's not true. And that's exactly the type of issue raised in that email, where it's an allegation about an abuse of power that, if
so
true...
So you did make the phone call after I suggested he could at least try to reach out?
The whole episode as described in that email is not accurate.
Is that true?
No, Senator, it's not true. And that's exactly the type of issue raised in that email, where it's an allegation about an abuse of power that, if
resolved the situation, whether his client had in fact reported or had not, and you wouldn't make it. So you're denying that that's true?
I do deny it, and I think the paragraph describes that one of my colleagues stepped in.
All right, let me go on to the next one. Thank you for giving me your answer. The prosecutorial misconduct scandal, that is of concern to me and presumably would be of great concern to you in your job as a prosecutor.
True.
What the judge found that errors were so severe that following a jury verdict in his favor, let me go on. The government determined that further prosecution of the case would not be in the interest of justice. This is a case where there were prosecutorial assets used. There was a conviction in your job as a prosecutor. The prosecution had to end, right? What?
I was one of the supervisors who participated in that decision because I was so disturbed by the violation.
But what the judge said, as I understand it, was that you offered little in the way of prosecutorial assets.
And so, as I've said, I respect Judge Nathan's decision. That aspect of the opinion.
But he said that, right?
It said that, but it was always difficult for me to square that with the fact that during the operative weekend, on both days, I was with the prosecutors. The record reflects that I spoke to the prosecutors at 10 o'clock on Saturday night, at 10 o'clock on Sunday night.
Well,
so again, I'm not perfect, but I did do my best there. My best wasn't enough, and I acknowledge that. But I don't think it's true that I didn't work hard on it.
Let me go on to a third thing. In 2021, the Southern District's Executive Committee initiated a formal investigation into your conduct. And my understanding is that after that happened, that's when you shortly thereafter left the Southern District. Is that correct?
No.
When did you leave the Southern District?
December of 2021.
December of 2021?
Yes.
Yeah, well, that's shortly after the 2021 investigation. Have you ever been asked or had to take anger management or behavioral management at the Southern District?
No.
All right. Who won the 2020 election for President of the United States?
President Biden was certified as the winner of that election.
So you give the standard answer. You can't say that he won because he got the majority of votes and also got the Electoral College victory?
I think the characterizations that you just made, Senator, are both political, and so I can't address them under the canons, and they're also tied up in ongoing litigation.
Help me understand how it's political to state who got the most votes in any election.
Senator, I'm just trying to be precise. The process by which our country declares the victor in an election is a certification process. President Biden was certified.
Okay. Thank you, Senator Welch.
Yield back. Thank you.
Senator Blackburn.
Thank you, Madam Chairman, and congratulations on your nomination. Madam Chairman, I want to talk for a few minutes about process. I have found it stunning that my Democratic colleagues have had such objections to process. So I thought I might revisit a little bit of this committee's history over the last few weeks. I think it would be instructive for the nominee and those that support him to be aware of this. Now, let's just go back to the Biden administration and point out a few things that happened not only to me, but to some of our Republican colleagues. Over the objections of Senator Hagerty and me, the Biden administration nominated not one, not two, but three nominees that we opposed. Now, some may like to say, well, you could have worked with White House on this, and we tried to, or you could have presented Democrat nominees, and indeed we did, repeatedly. But in the case of one of those nominees, Mathis, Chairman Durbin scheduled a hearing without even sending Senator Haggerty and I a blue slip. Now, what happened? The Democrats voted in lockstep to move him out of the committee. Another nominee, Carla Campbell, misled the committee during her confirmation hearing about her involvement with a radical far-left group that she worked with. And again, the Democrats were united in their support of that nominee. And then with Kevin Ritz, there were serious accusations of prosecutorial misconduct. And what did my colleagues on the other side of the dais do? They voted in lockstep. Now, they want to complain today, and some have spent their time complaining and griping about the way the committee has been handled, but they're forgetting about these. They forget about Senator Rick Scott and Senator Rubio, who opposed the nomination of Embry Kidd. But the Democrats moved forward with that. They were pleased to move forward with it. Senator Tillis and Senator Budd opposed the nomination of Ryan Park, but the Democrats chose to keep moving forward. And again, I would remind everyone, the senators were bringing forward Democrats that could have been the nominee. But instead, my friends across the dais decided they wanted those that were farther to the left, those that were activists, those that did not have judicial experience. They were looking for activists to put on the court. I'm going to read Senator Tillis's quote as we were approaching the markup of Mr. Park. He said, and I quote, "I'm going to tell you the same thing that when the rules are reversed, and they're going to be reversed, you're either going to make my job harder by doing the right thing and respecting your colleague today, or you're going to make my job easier because I'm going to go right down the line with the administration." Now, this is important to remember as we talk about process and as we discuss these nominees that are coming before us. There was very little respect that was shown the members on this side of the dais, and very little respect that was shown the nominees. And basically no consideration for the ability of a home state senator to weigh in on those that were being brought forward. So, Mr. Bove, I look forward to supporting you. I look forward to your confirmation. And my hope is that my colleagues across the dais will begin to think that it would be a good thing for them to reconsider, rewind the video, and play it so that you are refreshed on how you conducted yourselves during the Biden administration. I yield back.
Thank you, Senator Blackburn. Senator Padilla.
Thank you, Madam Chair. Colleagues, I want to begin with a couple statements, not specific to the nominee before us, Mr. Bove, but general observations as we've had hearings of nominees and on issues since the beginning of the year. It's become clear that President Trump clearly has one litmus test when selecting people to appoint. It's not experience. It's not dedication to our country or the rule of law. It's whether or not a potential nominee is willing to bend or ignore the law to satisfy the president's whims. Now, I understand that elections have consequences, and one consequence is that a president who is elected will get to nominate judges for the duration of his term or her term. But selecting someone with such a deep track record of vindictive, duplicitous behavior, of abuse of power, that is and must be treated as unacceptable. From Mr. Bove's time with the Southern District of New York to his time representing Donald Trump to his time at the Trump Justice Department, it's been demonstrated that he will not let the law stand in the way of doing what he wants. That's why as soon as Mr. Bove joined the Justice Department in an acting, unconfirmed capacity, he began an effort to purge the Department of Justice of perceived, quote, enemies, like the January 6th prosecutors. He even called the January 6th prosecutions, quote, a grave national injustice, and ordered the FBI to produce a list of everyone involved in them. Never mind the fact that he had previously worked on January 6th prosecutions while at the Southern District of New York. And that's why he ordered Southern District of New York prosecutors to dismiss criminal charges against New York Mayor Eric Adams in exchange for Mayor Adams helping to implement President Trump's radical immigration enforcement plan. Mr. Bove's actions in this case led 8 prosecutors, 8, including the interim U.S. Attorney, Danielle Sassoon, who had clerked for Justice Scalia, to resign. But instead of firing him, Donald Trump plans to give him a lifetime appointment to the Third Circuit Court of Appeals in New Jersey, a state that Mr. Bove has very, very little ties to. Now, it's not just Democrats who are concerned. Conservative judicial activist and former Republican staff member of this committee, Ed Wallen, who wrote that Bove has been called, quote, a savage, and likened him to a, quote, mafia henchman. Not my words, just quoting what's been submitted to this committee for consideration. The Wall Street Journal published an editorial urging this committee to ask questions about Bove's qualifications for this seat. They wrote, quote, does Emil Bove have the right judicial temperament? Does he have a judicial philosophy? It's seemingly clear that the more we learn, the answer is no. But we're here to ask questions, and I do have a couple of questions in my time remaining. Mr. Bove, can you share with us how many of the prosecutors assigned to the Capitol siege section were fired after you sent your memo on staffing at the Department of Justice?
I don't recall.
Ballpark?
I don't recall.
All right. Well, I'll submit that in the form of a question for the record to allow you time to jog your memory banks and try to give us a number or at least an estimate. Can you tell me how many January 6 rioters President Trump pardoned?
No, I don't recall.
Okay. Well, that actually kind of makes sense because I don't think when asked, the president himself couldn't give an exact number. When asked, his response was, quote, it would be very, very cumbersome to go and look. You know how many people we're talking about? 1,500 people. To think that on the first day in office, he would have considered case by case that volume of files to make the determination that they should be pardoned, that's clearly not believable. And we know that dozens of those pardoned had prior criminal records, including rape, sexual abuse of a minor, domestic violence, and more. Yes, I'm talking about the January 6th rioters. I'm going to end with this, Madam Chair. I can tell you that a long-serving prosecutor with the D.C. United States Attorney's Office thought that it sent a message that, quote, political violence toward a political goal is acceptable in a modern democratic society. Mr. Bove, you contributed to these actions. What do you think what kind of message do you think this sends to the American people?
I think that the president, in his exclusive discretion under the Constitution.
My question is, what message does this send to the American people? The pardoning of January 6th rioters, many with prior criminal convictions.
And you can answer briefly.
I think that's a question that calls for political views, and under the canons, I'm not able to take a position.
I thought we were talking about public safety and the rule of law. Thank you, Madam Chair.
Your Schiff.
Mr. Bove, I want to turn to the meeting that Mr. Ruvani, the whistleblower, has written an extensive complaint about. The hearing started with the chairman reading a social media post by the Deputy Attorney General Blanche, who is present today but not under oath, nor is that social media post under oath. So let me ask you, since you are under oath, in the complaint it says, Bove stated that DOJ would need to consider telling the courts, fuck you, and ignoring any such court order. Did you say anything of that kind in the meeting?
Senator, I have no recollection of saying anything of that kind. To the extent I
Wouldn't
used
you recall, Mr. Bove, if you said or suggested during a meeting with Justice Department lawyers that maybe they should consider telling the court, fuck you? It seems to me that would be something you'd remember, unless that's the kind of thing you say frequently.
Well, I've certainly said things encouraging litigators at the department to fight hard for valid positions that we have to take in defense of our
And have you
clients.
frequently suggested that they say, fuck you, and ignore court orders? Is that also something you frequently do, such you might not remember doing it on this occasion?
No, and as I explained, I have never directed.
So did you or did you not make those comments during that meeting?
Which comments, Senator?
You really need me to repeat it? Did you suggest, as Mr. Ruvani wrote, that DOJ would need to consider telling the courts, fuck you, and ignore any such court order?
I did not suggest that there would be any need to consider ignoring court orders. At the point of that meeting, there were no court orders to discuss.
Well, did you suggest telling the courts, fuck you, in any manner?
I don't recall.
You just don't remember that. Well, let me ask you this. It also says in the complaint, Bove indicated and stressed to all in attendance that the planes needed to take off no matter what. These are the planes that a judge was ordering not be used to render people to a maximum security prison outside the country. Did you say during that meeting, did you stress to all in attendance that the planes needed to take off no matter what?
Senator, your characterization is not accurate.
It's not my characterization. It's the characterization of a decorated prosecutor who was in that meeting. Are you saying that he's lying?
As I said at the beginning of the hearing.
No, I'm not interested in what you said at the beginning of the hearing. I'm interested in whether you stressed to people in attendance that the planes needed to take off no matter what. Did you say that?
I certainly conveyed the importance of the upcoming operation.
Well, don't paraphrase here. Did you tell people in attendance the planes needed to take off no matter what?
I don't recall the specific words that I used.
Wouldn't you recall saying that if you had instructed that the planes needed to take off no matter what, including whether the court ordered otherwise? You wouldn't remember that?
This is a mischaracterization, Senator. There were no court orders at this point.
Well, there was a court order, wasn't there?
No,
wasn't there a court order by Judge Boasberg, if not in this specific case, then in related cases, that people not be sent out of the country until the court could rule? Wasn't there a court order?
Not at the time of that meeting, Senator.
Did you participate in the decision not to disseminate that oral court order prior to the written court order to other agencies so those planes would not take off, so those planes would turn around? Were you involved in the decision to withhold that court order from the responsible agencies?
I think it's clear that I participated in this.
Yes or no?
I participated in this matter, and I'm not going to get into the contents of legal advice. I did, over the course of time, as many lawyers have,
No, I'm not
provide
interested in
advice
over
about
the course of
scope
time. I'm interested
court orders.
in whether you participated in the willful violation of court orders as alleged in this complaint. Let me ask you this, Mr. Bove, if there are notes of that meeting, will you provide them to this committee?
I defer to the committee and to the executive branch on the procedure.
And if the committee requests them, will you provide those notes to the committee?
I defer to the executive branch on the handling of that request.
And let me ask you about notes from another meeting which you're contesting here, and that is the meeting over the decision to dismiss the case in New York, the corruption case against the mayor of New York. According to Ms. Sassoon, the U.S. attorney at the time, during the meeting with Adams' attorneys, where she described Adams' attorneys repeatedly urging what amounted to a quid pro quo, that you admonished one of the lawyers in the room to stop taking notes. Is that true?
I don't believe I instructed that attorney to stop taking notes. I did remark on the fact that he was taking extensive notes, yes.
And why did it concern you that he was taking notes of that meeting?
Because at that point in the meeting, we were discussing who was responsible for media leaks, and I was making the point that only the prosecutors had created an extensive record that could support detailed leaks.
And you were concerned, were you, that information about this potential quid pro quo might become public? Was that the concern?
I've explained that there was no quid pro quo.
Will you provide the notes of that meeting, which you, according to the U.S. attorney, instructed be collected at the end of the meeting?
I think a member of my staff may have given that instruction outside my presence, and I defer to the committee and the executive branch on records requests and how those should be handled.
Well, I would request that we seek these records, which go to the truthfulness or lack of truthfulness of this witness. There's a reason why, if I may, my colleagues have gone over at least as much as this. There must be a reason why prosecutors quit rather than following orders from you they considered unethical. There must be a reason why prosecutors complained about you in your own office, why defense attorneys complained about you in your own office, why the judge in the case involving the dismissal of the charges in New York said everything here smacks of a bargain. You testified earlier that the objective evidence overwhelmingly made it clear that it was not a bargain. That there must be a reason why everyone disagrees with you, Mr. Bove, and people feel it necessary to give up a job they love at the Department of Justice and quit because they won't go along with what they consider unethical and immoral orders from you. There must be a reason why that is so true of so many, and this court needs to get to the bottom of it. I yield back.
Well, as a former judge, I like being referred to as the court. But as the chair, I will turn it over to Senator Cruz.
Thank you, Madam Chair. And I think robes would look damn fine on you. Welcome, Mr. Bove. Congratulations on your nomination. Your record is exceptional, prosecuting terrorists and spies and cyber criminals and major traffickers. You've dedicated your career to protecting the American people and upholding the rule of law. Your nomination reflects exactly what our judiciary needs: serious, experienced, rule of law-oriented individuals who understand the limited role of the courts in our constitutional system. You are President Trump's second appellate court nominee in this second term. You and Ms. Hermendorfer, President Trump's first appellate nominee, share the distinction of being tapped to fill appellate seats that remained vacant, not because of delay or inaction, but because President Biden's nominees were simply too extreme for the Senate to confirm them. In your case, the seat had previously been offered to Adil Manji, a nominee whose radical affiliations made clear that he was unfit for the federal bench. Manji was tied to a law center that hosted terrorists, that promoted anti-Semitic rhetoric, and that attacked repeatedly law enforcement. When given the opportunity to repudiate those views, he declined. His nomination failed, and rightly so. Now, rather than own that failure, Democrats are reaching for innuendo, rumor, and political theater. They're trying to paint mainstream Trump nominees as quote-unquote controversial to distract from the fact that their own nominees were so out of step with basic standards of judicial temperament and constitutional fidelity. The contrast is obvious. President Trump is restoring normalcy to the judiciary, nominating judges who will apply the law, who will respect the Constitution, who understand that justice is not a tool for activism. That's especially true and important at the appellate level. Circuit judges serve as a critical check on activist district judges who seek to override national policy and impose their own ideological will. They also stand as a safeguard against prosecutors who are willing to politicize justice. I will say I find myself amused listening to my Democrat colleagues as they clutch their pearls in utter horror that the Department of Justice is deporting violent, criminal, illegal aliens. Oh my goodness, murderers, rapists, child molesters, Venezuelan gang members, how dare you remove them from America? Don't you know that wife-beating gang members are appropriate to have daiquiris with in El Salvador? Don't you know that America-hating anti-Semites you should dance in celebration with, come back to our campuses and terrorize our Jewish students? That's what the Democrats on this committee stand for. More criminals, more murderers, more rapists, more child molesters, and more Venezuelan gang members. Democrats on this committee got up on their high horse that the MS-13 gang member deported to El Salvador must come back to America. Well, you know what? He did. And he's being prosecuted for human trafficking. I've read every word of the indictment. 10 years of human trafficking with MS-13. This is the poster child for who the Democrats want more of in the United States of America. And somehow, you're the villain because you are a real prosecutor willing to enforce the law and remove dangerous criminals from being in a position to threaten American citizens. Let me say on behalf of 31 million people in Texas, thank you. Thank you for answering the call. Thank you for stepping forward and fighting to keep American citizens safe. Let me ask you, in your view, if you're confirmed as a judge, what is the importance of the Constitution and what is the importance of the rule of law?
Singularly important. The Constitution defines the mechanism for the entire republic. Adherence to it could not be more important. Article 3 and its restraints would guide me in the exercise of judicial power, and I would do everything that I could to enforce the Constitution faithfully based on the rule of law.
So I commend you for that answer. I also commend you for knowing what Article 3 is. I'll point out that President Biden nominated to be an Article 3 judge an individual who did not know what Article 5 of the Constitution was, and stunningly did not know what Article 2 was either. I will say in the annals of unqualified judicial nominees, the Biden administration managed to take the gold, and it is refreshing to have someone who is actually qualified nominated to the court. Thank you.
Madam Chair, before we recess,
Thank
may
you,
I make
Senator
a
Cruz.
parliamentary inquiry?
Go ahead, sir.
Thank you, Madam Chair. I've requested the notes from two pivotal meetings that go to the heart of the nominee's credibility. The meeting over the decision to drop charges against the mayor of New York, and the meeting in which the whistleblower alleges that the nominee suggested ignoring court orders and telling the courts essentially, fuck you. The witness has said that the decision whether to turn over those notes will determine or depend, I guess, on whether there's an assertion of privilege of some kind. And we have the great good fortune at this moment to have the Attorney General and the Deputy Attorney General here with us today. We can resolve this right now. I would ask through the chair whether the Attorney General and the Deputy Attorney General will approve the provision of these notes to the committee. They could be provided to the chair and the ranking member in camera if necessary, so that the question that Senator Kennedy asked about whether there was some illicit bargain and that my colleagues have asked can be resolved. If there are detailed notes of these meetings, it will give us an answer to who's telling the truth here. So I would ask the question through the chair of the witness. Given we have the Attorney General and Deputy Attorney General here, will the Attorney General and Deputy Attorney General make these notes available to the committee so we can determine who's...
We're also going
Madam
to turn
Chair.
it over to Ranking Member Durbin, who had some letters, I believe, he wanted to introduce for the record.
Well, I'd like to join Senator Schiff in his request. I think that if these notes exist, they would answer the questions which the witness was unable to answer. And I think that would be a lot of clarity in that situation.
Well, that will be noted, Ranking Member, and we will add you to that request, and you may submit those through the notes. Did you have additional documents
I do.
introduced for the
I
record?
ask consent that a letter from Senator Kim of New Jersey be entered into the record.
Without objection?
I ask unanimous consent that a letter from the Rule of Law Institute, a group of conservative lawyers opposing this nomination, be also entered into the record.
Without objection? Senator Blumenthal?
Yes, Madam Chair. I'd like to enter into the record. I believe that Senator Grassley may already have included it, but page 23 of the record of this nominee's appearance before Judge Ho, which relates to his stating, and I'm quoting, in an exercise of prosecutorial discretion, is, I think, as Your Honor alluded to earlier, virtually unreviewable in this courtroom, especially where guided by an executive order and direct guidance from the Attorney General referring to dismissal of criminal charges. He said that he never said it, and in addition to asking that this be included in the record, I also like to ask for another round of questioning.
We're not going to proceed to another round. Is there any objection that it be included? Without objection, it'll be included for the record, and if you have additional questions, please submit them to the committee, and we'll make sure they're forwarded on.
Thank you.
Thank you. All right, this concludes panel one.
May I submit some things for the record, please? I was beaten.
I'm so sorry. You have additional things to submit for the record?
I do.
Go ahead.
Madam Chairwoman. First of all, I want to thank you, the ranking member, for submitting Andy Kim's statement for the record. I had intended to do that, but given some of the aspersions that were made about Adil Mungi, I want to resubmit into this hearing letters from numerous Jewish groups as well as independent legal groups testifying to his character and honor and, again, the ill way in which he was treated.
Do you have those with you for submission?
I do have those with us for submission, and we'll
Okay.
put them before the committee.
Without objection, they'll be admitted. All right, we will now turn to panel two. Thank you for your testimony here today, Mr. Bove. Thank you for the Attorney General, Pam Bondi, for being here today, as well as our Deputy Attorney General, Todd Blanche, and all of, I see your colleagues from the Department of Justice and former colleagues that are present. We appreciate you being here and being a part of this process. And I would now ask the 4 district court nominees to please come forward and take your places at the witness table. All right. I will. All right, you did that faster than I anticipated. Thank you so much for being so expedient. I will now administer the oath. Would you all raise your right hand, please, and answer this question? Do you swear that the testimony you are about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? All right, go ahead and have a seat. It is our normal process if you desire to introduce people that are with you, including your family, and then you may give your opening statement. We'll start with Judge Artau and then go to Judge Dudek, Judge Moe, and finally to Judge Pratt. Judge Artau, the floor is yours.
Madam Chair, may I ask a question?
Yes, sir.
I assume the introduction of guests is included in the time for their opening statement?
Yes, I will ask that it be.
Thank you.
Thank you. I would like to thank Chairman Grassley, Ranking Member Durbin, and of course Acting Chair Moody, and all the members of the Senate Judiciary Committee, as well as my home state senators, Rick Scott and Ashley Moody, for this incredible opportunity. I also want to thank President Trump for the great honor of this nomination. And most importantly, I want to thank the Almighty God who makes all things possible. I am humbled by the President's nomination, but also proud that so many have traveled here today to support my nomination. First, I would like to introduce my ex-wife, Donna, who is here to support my nomination, together with our son, Christian. I'm very grateful to both of them for their support. Next, I would like to introduce a group of lawyers and community leaders who are here to support my nomination, including representatives from the Trial Lawyers Bar, the Defense Bar, the Hispanic Bar, and other community-based groups. We have here today Bradford Cohen, Fred Cunningham, Jason Gonzalez, Howard Weiss, Robert Harvey, Charbel Barakat, Gordon Dieterle, John Anthony, Braulio Rosa, and last but not least, Sean Dominic. I'd like to point out that Sean Dominic is the immediate past president of the American Association for Justice, not just the local president, but very impressively, he's the president of the Association for Justice throughout our nation. I am very, very honored to have such a diverse group of community leaders and leaders from all aspects of the Bar Association here to support my nomination. I also want to thank my law students from St. Thomas University, where I teach as an adjunct professor, for tuning in today to watch this hearing. Before I conclude, I would like to say something about my parents, who could not travel to attend today, but who are watching from home. They came to America with only the clothes on their back to flee the tyranny of communism that had gripped their native Cuba in 1962. My father worked hard in a manufacturing job as a tool and die maker after arriving from Cuba in pursuit of the American dream. But when he lost his job because the manufacturing sector left America, he did not give up on the American dream. He worked even harder in any job he could find in the hope that his children would experience the fruit of his hard work and determination. The American dream is part of our unique American story, founded on the concept expressed in our Declaration of Independence, that all have been created equal, endowed by our Creator with certain unalienable rights, among which are life, liberty, and the pursuit of happiness. I'm here today as a testament that the American dream is alive and well, because only in America can the son of Cuban exiles who arrived with nothing more than the clothes on their back have an opportunity to attend one of America's finest law schools at Georgetown University. And only in America can the son of a displaced tool and die maker have had the opportunity to serve the state as an appellate judge, a trial judge, and as general counsel of a significant agency. And lastly, only in America can a first-generation American like me be nominated to serve on the federal judiciary and have an opportunity to appear before the world's greatest deliberative body. Thank you, Senators, for the opportunity to provide you with my opening remarks. I'm happy to answer any questions you may have.
Thank you. Judge Dudek.
Thank you, Senator Moody. And thank you, Chairman Grassley and Ranking Member Durbin, for holding this hearing. And thank you to Senator Scott for the warm introduction. I would also like to thank President Trump for the nomination and the opportunity to be here today. It is an honor to be nominated to a district court seat on the Middle District of Florida, which has become my adopted home. I'm joined today by several members of my family who I would like to briefly recognize. My wife, Casey, who's been my biggest advocate and supporter. I certainly would not be here without her encouragement. My parents, Bob and Cindy, who have both sacrificed so much to help me reach my goals. And finally, my brother and sister-in-law, Eric and Emily. For the sanity of everyone here, I've left my children at home, but I know they are cheering for me from there. Like many of the past judicial nominees you've heard from, I'm here only through the support of others. There are far too many to thank, but I did want to recognize a few who have been kind enough to invest their time and energy into my nomination today. They include Ed Sheffy, Tom Grady, Fred Pozeshkin, Jesse Benall, and Mark Boyle. There's also my court family who spent countless hours helping me assemble materials for the hearing today. They include Bridget Willauer, Courtney Ward, Dylan Mayer. I cannot thank each of you enough for your encouragement and help. And finally, I'd like to thank the judges who I was lucky enough to clerk for early in my career. They include Judge Jonathan Thatcher, Judge James Kacharis, and Judge Stephen Agee. Each of you taught me to respect the rule of law and the role a judge plays in it, and I hope to continue those values if I am confirmed on a seat in the Middle District of Florida. And thank you, and with that, I look forward to your questions.
I said Judge Moe would be next, but we'll start with Judge Pratt. You can skip her if you'd like.
Thank you, Senator. Thanks also to all of the members of this committee, including the chairman and ranking member, for holding this hearing on my nomination. It is an honor to be here before you. I thank President Trump for the honor of this nomination and this opportunity. And I, too, just want to limit my opening remarks to thanks. There are far too many to mention, but I'm going to mention as many as I can in the short time that I'd like to spend. First, I want to thank God. It is through His hand and His hand alone that I can appear before this committee today. But of course, I have seen His hand in my life through the work of others, and I have some of those people here today. First and foremost, I want to thank my wife, Christine, whose intelligence and beauty are matched only by her patience and grace, as she has endured all of the job changes and moves that we have experienced as a family, and we're now happy to be back in our home state of Florida. I also want to acknowledge my 3 children, who, I'll share a little bit. I think that they are really relishing this opportunity. Like many during the COVID pandemic, we had an opportunity to try our hand at a bit of homeschooling. Our civics lessons, however, I felt like were not complete until today. So they are very much enjoying this field trip and learning a lot, and I know very excited to be here. I want to thank my parents, Eric and Jill, who are here also today. And their advice to me now, as always, has been to pursue what brings me fulfillment and what allows me to serve others and do the most good. That is why I'm here today, and I thank them for that lesson. My siblings, Josh, Jillian, and Hunter, are all here, and I couldn't think of a better cohort to grow up with. I also want to thank Senators Moody and Scott for their support. I want to thank my current colleagues on the 5th District Court of Appeal, including our Chief Judge, Jim Edwards, and our soon-to-be Chief Judge, Harvey J., who have been mentors for me on the court. And I also want to thank Attorney General Bondi and Senator Moody as well for the opportunity to serve as their Deputy Solicitor General during my time in Tallahassee. I think that was a formative experience and part of the road that has brought me here. And then finally, I want to thank the judges for whom I had the blessing to clerk. I clerked for Judge Schlesinger, who sits on the Middle District of Florida, and I believe that he's watching from home. I also clerked for now Chief Judge Jennifer Walker Elrod of the U.S. Court of Appeals for the 5th Circuit. From both of them, I had model judicial role models who really exemplify, I think, the very best of the judicial calling. And I'm very proud to have clerked for both of them, and I hope that they can feel the same way about me and my service. So thank you very much. I look forward to your questions.
Thank you. And finally, Judge Moe.
Thank you, Chair Moody and Ranking Member Durbin, the members of this committee. I want to begin by, of course, thanking President Trump for the tremendous honor of this nomination and for the trust and confidence he's placed in me. I want to thank Senator Scott and you, again, Senator Moody, for your support. It means the world to me as your former colleague on the 13th Circuit for a very brief period of time to have your support today. I want to thank my husband, Ben. If you could understand the extent to which my husband does real, serious, stressful, difficult work, and yet he still finds time on a day like today to have flown across the country to pick up our boys from summer camp, flown through the night to bring them here, to make sure that they're dressed, their hair is combed, and their behavior is good during this hearing. There are few men in the world who are like my husband, and I think that I would be terribly remiss if I did not begin by emphasizing the great respect that I have for him as a man. I also want to thank my boys. They've done a great job here today. They've gotten to see some interesting things. I'm proud of them, as I always am, and as their father always is as well. I want to thank my mom and dad. My mom and dad would be here for any reason if I asked them to. There is nothing that I've ever done that was of any significance at all to me that they have ever missed. And it's no surprise to me that they're here because they don't miss anything that matters to my brother and I. I want to thank them for their love and their support, their counsel and their guidance throughout all of my life. And I am very grateful to have their support here today. My older brother, Blake, is watching with his children in Tampa from their law firm, along with their law partners. His support and encouragement has always been a tremendous blessing in my life. I'm very proud of him as well. My mother and father-in-law, Tim and Carrie Moe, are watching online. I love them very much. I'm so incredibly blessed to have married into their family and to have their support throughout the years. I want to thank the person who I trace much of what we're here today back to, and that is Judge Virginia Covington. She's traveled to be here to support me today. Judge Covington took a chance on me right out of law school. I'll never forget it. I'll be forever grateful for the opportunity she gave me, number one, but also the chance that I had to watch someone who takes this job so seriously and who works so hard and applies herself to the rule of law so faithfully. To learn from her for the first 2 years of my career was tremendous. I also want to thank former Justice Bell. I interned for him in law school. Also Judge Jeffrey Hotham of the Maricopa County Superior Court. Both of them were also excellent examples early in my life of what a good judge does and how they behave. I want to thank my Aunt Peggy, who traveled here from Texas to be here today. I also want to thank my friend Kelly, who's joined us today. I have many family and friends who are watching online and supporting me through distance. But I just want them all to know how much I appreciate them, and my failure to name all of them individually can only be explained by the fact that I can't take up the entire hour. I want to thank my colleagues on the 2nd District Court of Appeal, my former colleagues on the 13th Circuit, and my former law partners at Bush Ross, as well as my judicial assistant, Julie Forgas, and my law clerks, Tyler and Dean. I thank you all for your time.
Thank you so much. And I'm going to go ahead and defer to Senator Kennedy to kick us off.
Thank you, Madam Chair. Judge Dudick, did I say that name right?
That's correct, Senator.
All right, what's the warrant requirement?
Well, before the court would issue a warrant, you have to assess to make sure that there's probable cause to either search the place.
When's a warrant required?
Excuse me?
When is a warrant required?
The general rule is a warrant is required any time that the government wants to search a person, place, or thing.
Could you speak into the mic?
Oh, I'm sorry, Senator. Yeah, I said the backdrop rule is that a warrant is required any time the government wants to search a person, place, or a thing.
And to arrest you, right?
There are some exceptions to that, but generally, yes.
Okay. And there are exceptions to the warrant requirement for searching and arresting people, are they not? Are there not?
Yes, Senator, there are.
Okay. Suppose the Florida Supreme Court ruled that here in Florida, we're not going to recognize any exceptions to the warrant requirement. You have to have a warrant to search someone, and you have to have a warrant to arrest someone. Mm-hmm. No exceptions. Can the Florida Supreme Court do that?
Well, Senator, under the Supremacy Clause, they'd be bound by what the Fourth Amendment dictates. Of course, they're free to make their own requirements as it.
What if the Florida Supreme Court did it under the Florida Constitution and not the federal Constitution?
Well, they would still, Senator, have to apply with what the federal Constitution said.
No, they wouldn't.
under the supremacy
Do
clause.
you know what adequate and independent state grounds means?
Sure. Of course, I would understand that they could have independent and adequate state grounds for state law, but they.
No, they don't. As long as you don't take away rights, but add to them, a state can do whatever it wants to under its state constitution, can it?
Yes, sir. Yes,
But that's
Senator.
not what you just said. You think the supremacy clause applies? The supremacy clause applies.
Well,
You want to change your answer?
Senator, I would like to change my answer to the extent that I agree with you that the Florida legislature or Florida could do exactly what you said. I meant in my statement is that.
Trust me, it can. Judge Pruitt, I'm sorry, I can't see that far.
It's Judge Pratt, Senator. Yes.
Judge Pratt, I apologize, I can't see that far. Can a state legislature pass a law that discriminates against a group of people over another group of people for inferior treatment?
Well, Senator, the federal constitution and the state constitution both contain protections against various forms of discrimination.
But can a state legislature say this group, we're going to treat this group of people differently than another group of people?
So I think, Senator, an example where a legislature
Tell
could
me first if a state can do that.
Yes, a state can, for example, require a driving age, which discriminates on the basis of age. To say, for example,
When can a state legislature not do that?
when it's seeking to do so under a basis that is protected under the state or federal constitution.
Okay, good. Judge, tell me about the privileges and immunities clause.
The Privileges and Immunities Clause, there's a privileges and immunities and a privileges or immunities clause. There's one of each. One of them relates.
Privileges and is what I'm asking you about.
I believe you're referring to what came through in one of the Reconstruction amendments and discussing the fact that that the privileges and immunities of citizenship would be extended under those.
First, what article is it in?
I believe it's in the 13th Amendment.
No, 4th. Article 4. What does it do?
Senator, you have pinpointed a question that in my 9 years as a judge, in my decade of private practice before this, my 2 years as a law clerk, my 2 years on law review in law school, including a year as editor-in-chief, didn't ever come up.
You tell me you don't know.
So it's an interesting question.
Yes,
and
ma'am. I know it's interesting. That's why I ask it.
Yes.
But you don't know the answer. Just tell me. I got a lot of ground to cover here.
I would be very happy to research it.
Okay. Do you know what the privileges or immunities clause is?
With respect to my answer would be the same on that.
You don't know it either.
Well, with respect to the privileges and immunities of citizenship, my recollection is that
privileges are immunities.
Yes, my recollection is that was discussed in one of the Reconstruction amendments.
Which one do you know?
I believe it was the 13th or the 14th.
Okay. All right, Judge. What's Title VI of the Civil Rights Act of '64 do? Ma'am?
Which judge?
This judge down here on the far end.
Artau?
I can't see that far.
Just making sure, because there's 4 judges there. Judge Artau, I'm going to let you answer that briefly.
Hey, I want to reclaim my time, Mr. Chairman.
You can
Madam
answer
Chairman.
that briefly.
Judge, what's Title VI of the Civil Rights Act do?
I believe that ensures that people are treated equally in any places that they would be, that they would not be discriminated against.
In all cases?
Refresh my recollection as to what what you were referring to,
I'm
Senator.
referring to Title VI of the Civil Rights Act of 1964, which you're going to see every other Thursday as a federal judge.
So I believe that that's under the Commerce Clause. They wanted to make sure that there was not any discrimination going on with regard to race, and that was addressing
it. It prohibits discriminating on the basis of race or color or national origin. Under what circumstance? Do you know the answer?
Under any circumstances where you're providing services to people?
No, it's only if you're getting federal money. You need to brush up on that one. I'm way over my time. Thank you, Madam Chair.
Thank you, Senator Kennedy. Senator Durbin, Ranking Member.
It's been a long time since I took a bar exam, and I remember getting the envelope that said with good news that I had been accepted. And I breathed a sigh of relief to think I'd never have to face another test. Well, you've just gone through the Senator Kennedy bar exam. It's been a tough one for a lot of nominees. And lucky for us, he doesn't ask his colleagues these questions, only the nominees. So I wish you well, and I acknowledge you asked some tough questions, Senator. Judge Pratt, just a few weeks ago, you...
It's only a position for life, Mr.
Understood.
Mr. Chairman.
Judge Pratt, a few weeks ago, you wrote an opinion in which you held that a Florida law allowing minors seeking abortions without parental consent, but with judicial waiver, was unconstitutional. The case involved an appeal from the trial court's denial of a 17-year-old's application to obtain a judicial waiver of the parental notification and consent requirements for an abortion. Under Florida law, judicial waivers in this context have been permitted. However, your decision held that Florida's judicial waiver procedures were unconstitutional and violated the parent's due process right. This wasn't something you wrote in an op-ed piece, nor was it a case you argued zealously on behalf of a client. This was last month, and you wrote this opinion as a state court judge. In commenting on your opinion, one lawyer said judicial override doesn't even begin to describe what this judge did. There are also serious concerns with your decision's potential impact on victims of incest or abuse. So, should a minor who is sexually assaulted in your state be forced to give birth if her parents do not consent to her having an abortion?
Senator, my opinion on behalf of our court expressly made clear that that was not a situation that was presented in the case. The case concerned a waiver request on the basis that the minor asserted that it would be in her best interest not to include her parents, not to allow her parents to be notified of her contemplated procedure. And as the opinion, explains, I think I don't want to go behind the face of the opinion, but I'm happy to explain the opinion. The opinion holds that the parents have, at a minimum, a due process right to notice, an opportunity to be heard, and this is presumptively fit parents, have a right to notice, an opportunity to be heard if the state seeks to abridge or to remove their right to be involved in the medical decisions of their children. So that is the basis of the opinion.
I think you went further than that, as I understand it. Your decision held that Florida's judicial waiver procedures were unconstitutional and violated the parents' due process rights. Unconstitutional under the I don't know the Florida Constitution, obviously, but your argument was that it was unconstitutional under state constitution or federal.
So, Senator, it wasn't my argument, but the reasoning of the opinion that I authored on behalf of the court is that the due process clause of the 14th Amendment to the United States Constitution requires, as with any other circumstance when someone's substantial rights are at issue, notice and opportunity to be heard, essentially a opportunity to provide an explanation to the court why the court should or should not take the contemplated action. And there's a body of precedent that the opinion cites regarding the fundamental requisites of the due process clause being notice and opportunity to be heard.
Different states have different laws, and certainly the judicial waiver is put in place so that when there's a question of parental consent, there's an option for the victim to petition the court for permission to apply the waiver. And as I understand it, you found that petition to apply the waiver unconstitutional. That's the way I read this. Let me ask each of you, we've had a recurring question here about the impact of a court order. How seriously should a party to a conflict take a court order? Judge Ortaw?
Very seriously.
And do I have the right, if I'm in your court, or any court for that matter, and a decision is reached, to say that I just don't agree with it, I don't have to live by it, or am I bound by that order until I've exhausted rights of appeal, for example?
Well, Senator, there are stays that can be pursued. Of course, there's appeals that can be exhausted that may be able to be exhausted. You may be able to post a bond to exhaust such things. You may be able to move for rehearing on it. There may be some exceptions, but for the most part, court orders are court orders.
Well, and I think you just heard, you sat through several hours of questioning on a potential nominee for the circuit court as to whether or not he was following the court order, oral or written, I'm not sure, when it came to launching a plane with detainees in it to another country. So this is a serious question which is going to recur frequently here, I'm afraid, under this administration. I yield at this point.
Thank you, Ranking Member. Senator Whitehouse, do you want to go ahead and go?
Sure. Thanks, Chairman. If you don't mind, could I start my questioning in just a moment and make a point of order or an observation? I didn't want to interrupt the questioning of Mr. Bove. The chairman had signaled that he didn't want any further interruptions. But I did want to point out, with respect to my concern, that Mr. Bove was failing.
You don't have a point of order regarding this panel.
No, the previous one.
If you would just hold that until we're through this, and you're more than welcome to do it at the end of the
Do you mind if
hearing.
I do it now? I'm here. It'll just take a minute.
Go ahead and start your questioning so we can keep the record clean. So go ahead and ask your questions.
Mr. Pratt, is it true that you were a fellow at Claremont Institute Center for Constitutional Jurisprudence, founded and run by John Eastman?
I was a John Marshall Fellow. I believe that year is correct. I believe that's correct, Senator.
Are you aware of Mr. Eastman's role in supplying Donald Trump with the false argument that Vice President Pence could overturn the 2020 election?
I don't have personal knowledge of the situation you're describing. I'm aware generally of news reports and headlines, but I would say that my knowledge is very limited, Senator.
Your knowledge on that is limited to what you've read in the public media?
That's correct.
You haven't had conversations with Eastman about it?
No, I don't. I've not had a conversation.
Is it true that you are a senior counsel at First Liberty Institute, an institute overseen by Kelly Shackelford?
Yes, that's right, Senator.
Are you aware that in December of 2020, Kelly Shackelford signed a letter urging United States senators to try to overturn the 2020 election?
So I don't recall the content precisely of that letter, Senator, and I'm not prepared to speak about the characterization of that letter. I do know that he signed a letter in about that time frame concerning the general subject matter of the election.
Have you discussed that letter with Mr. Shackelford?
No, I have not.
Do you know Ken Klakowski, who was also senior counsel at First Liberty?
I believe I have met him twice.
Are you aware of his role in helping Jeffrey Clark draft the letter that Clark wanted the Department of Justice to send to states, specifically Georgia, in an effort to overturn the 2020 election?
I'm not, Senator.
And have you had any conversation in those two meetings with Mr. Klakowski with him regarding that letter or that effort?
I don't recall ever having a conversation with him about that, no.
Do you know Jeffrey Clark, who wrote that letter?
He worked at the Department of Justice during the same time frame that I was there. I believe that I had been in maybe a couple of meetings where maybe his staff was present and I saw him in the hallway, but I don't know him well, Senator, no.
And you did not discuss with him that letter?
No, Senator.
Okay. You were a fellow at the Leo 9 Forum, which I guess is not Leonard Leo and the number 9. It's as in like a lion. Do you know Leonard Leo? He's involved in that group.
I have met Mr. Leo on a couple of occasions. It's been a while since I've seen him, Senator.
Do you agree with President Trump's comments that he is a sleazebag who hates America?
So, Senator, I understand that you're asking me to comment on posts that the president has made on social media. As a sitting judge and as a nominee to a federal vacancy, it would be inappropriate for me to comment on the content of the president's social media feed. The canons preclude me from stating a position on matters of public and political controversy.
Okay, let's turn to experience. How many cases have you personally tried to verdict or final judgment in court before a judge or jury?
My judiciary questionnaire should list the cases I believe as lead counsel. That would be 2, Senator.
Have you ever drafted a complaint?
I have, Senator, yes.
Have you ever drafted an answer?
Yes, I believe so. Maybe not in total, but certainly in part.
Have you ever conducted pretrial discovery?
Depends on what you mean by conduct. I have been on teams that have been involved in discovery matters and have supervised trial teams, and I have argued in opposition to a motion to compel.
Have you ever conducted a voir dire?
I have not, Senator, no.
Have you ever conducted a direct examination of a courtroom witness?
So, Senator, during my time as an attorney, I have focused on appellate matters, issues and appeals.
So the answer would be no to that?
I believe the answer is no, Senator.
Have you ever conducted a cross-examination of a courtroom witness?
Again, Senator, it's the same answer. My practice did not focus on
matters. Have you ever argued
matters.
a motion in limine?
No, Senator, I don't believe that I have. Again, my practice is centered on issues and appeals. I have practiced at every level of the state and federal court system. I've handled matters in federal and state trial courts, federal and state appellate courts, and the U.S. and Florida Supreme Courts.
My time has expired.
Thank you, Senator Whitehouse. Senator Blumenthal.
Thank you, Madam Chair. Mr. Artow, if the Secretary of Defense were sued in your courtroom as a district court judge, if you are confirmed, and you issued an order, would you expect him to obey it?
If I had jurisdiction over the matter, if I decided that it was...
You wouldn't issue an order if you didn't have jurisdiction. It's a yes or no question. Would you expect him to obey it?
I would expect all parties to obey my orders, no matter who they are.
Because an order is an order, as you just said, correct? So the Secretary of Defense ought to obey a district court order. How about you, Mr. Dudek? What do you think? Judge Dudek.
Yeah, I would expect, as Judge Artow said, all parties before me to follow my orders pending any
Including
appeal.
the Secretary of Defense or any other cabinet secretary, correct?
Any party that appeared before me outside of a stay or an appeal, yes, I would expect that.
Judge Pratt?
I'd give the same answer as my friends.
Judge Moe?
Same.
Judge Artow, as you know, the president sued the Pulitzer Prize Board for defamation and conspiracy based on their awarding of a prize to journalists who reported on the Trump-Russia collusion during the 2016 election. You're familiar with that lawsuit, correct?
Yes.
You sat on the court that dismissed it.
I sat on a court that found jurisdiction, on a 3-judge panel that found jurisdiction.
And you wrote a concurrence where you took a somewhat less measured approach. You essentially parroted the litigant, Trump's talking points, incorrectly calling the Russia story, quote, now debunked allegations, end quote, and you called into question the seminal Supreme Court decision in New York Times versus Sullivan, a landmark case protecting free speech and freedom of the press. Given that concurrence and the false information that you included in it, should litigants have any expectation that you can be unbiased especially if the federal government is involved as a party.
Senator, I've been a judge. I've been a judge for 11 years. Nobody's ever questioned my integrity. With regard to, I know that what you're getting at in terms of the issue, but I had no communications or expectation that I was even under consideration by the White House when I issued that opinion. And I followed the canons. I followed the canon 3, which is the one that applies in Florida, very carefully. It requires me to take cases as they come.
Let me just ask you, because my time is limited.
Okay.
That court ruling was issued on February 12th of this year, correct?
Correct.
Had you, before that date, ever spoken to Senators Moody or Scott about the possibility of being considered for a judicial vacancy?
I had talked a few years ago with Senator Scott, because Senator Scott, during the last administration, had me on his list, and his general counsel is a friend of mine. And when I came into town in November to attend the Federal Society, I just basically paid him a courtesy visit like I do every year, because he's a close friend from Palm Beach County, where he used to work as an assistant state attorney. I had no expectations of anything other than the fact that I knew Senator Scott had me in high regard.
So the answer is yes. You had spoken to Senator Scott through his staff about the possibility of a judicial vacancy.
For the last several years.
Repeatedly, you had discussed with Senator Scott's staff the possibility of a judicial.
I was aware that they considered me in high regard, and that if there was an opportunity that they might consider me for it, I was asked if I had any interest in it, and I had indicated that I did. But of course, Senator Scott did not have a case before me, and I was not communicating with the White House or anybody else. Had the timing been differently, then I may have handled it differently.
Why didn't you recuse yourself from a case involving the president when you had spoken to Senator Scott's staff about the possibility of a judicial vacancy that would involve an appointment by the president who was a litigant?
Because Canon 3B requires that a judge hear and decide matters assigned to the judge, except if the disqualification is required by 3E. And 3E has only 4 different bases that could possibly apply to me: personal bias or prejudice. I didn't have any personal bias or prejudice in the case. I did not serve as a lower court judge, and I had no economic interest in the subject controversy itself.
That canon 20 times, but the fact is that you had spoken to Senator Scott's office about the possibility of a judicial vacancy, knowing that Senator Scott would hear about it, and then sat on the case. Let me just ask you.
I had done that when Joe Biden was president, and that's the timing that we're talking about.
Well,
I can't indefinitely not take cases because of the fact that I might have aspirations for higher office. That's not the way it works in terms of the canons.
And Senator Blumenthal, your time has run. Did you have one more quick question? Go ahead.
I have one more question. Had you spoken to anyone else, including Senator Moody, about the possibility of a judicial appointment at the federal bench?
I never spoke with Senator Moody. I never spoke with Senator Moody.
Or anyone else?
Senator, I think I passed on. I think Senator Scott passed on my resume, perhaps, and I indicated that I'm available if they have any questions. But I did not hear back from Senator Moody's office because Senator Moody was just coming into transition at the time.
Thank you.
Thank you, Senator Blumenthal. Senator Padilla.
Thank you, Madam Chair. Good afternoon now to all of you. Appreciate your patience. Appreciate you being here today. The first couple questions I have, I believe, are pretty straightforward. So I'm going to, in the first one, ask for a yes or no answer. It's a subject area that some of my colleagues have raised, but I'm going to be as direct as I can. The question is this. Are members of the executive branch required to follow court orders? We'll begin with Mr. Artel.
I think as I answered before, generally speaking, all parties that are subjected to a court order are required to follow orders.
That's a yes.
There are a few exceptions, but like appeals, stays.
I'll get to it in a second.
Yeah.
Let's go down the
Sure, Senator, outside of the exceptions that were mentioned, then that's a yes.
Same answer, Senator.
My answer is the same.
Right. And I, been hearing, well, there's exceptions. What is the appropriate way or options for a litigant to respond to a court order they think was incorrectly decided? And I'm talking district and circuit court level. What are the options if you disagree with the ruling or finding?
Would you like me to start, Senator?
Yes,
to seek a stay, to seek rehearing, to seek an appeal, to explain why it would not be possible, to perhaps put in some evidence to that regard.
Not just explaining to the general public, right? The judicial process, seek a stay, seek an appeal. There's mechanisms for registering your disagreement, right? And finding another day in court. Let's continue.
I agree with Judge Artao's statement. Those exceptions are the appropriate mechanisms to.
Thank you.
Keep my answer short. Yes, there are various mechanisms to seek review or stay of a court order with which a party disagrees.
And I agree with those answers.
Right. So I didn't hear any of you say that just disregarding or dismissing court orders is an option. I don't want to speak for you. If anybody disagrees with that, my interpretation from your answers is dismissing or disregarding court orders is not an option. You can register your objection at this point. Seeing none, thank you for that. So this next question is, as I'm a member of the Senate Judiciary Committee and your judicial nominees before us, but my motive for asking you this question is actually just at a basic human level. We're living at a time where the President of the United States has not been shy about expressing his disapproval of so many figures in our country, but members of the judiciary, judges, and justices are not an exception to that. When there are cases that are found against his interest, against his agenda, against his favor, he has on multiple occasions either directly or indirectly criticized, some say harassed, or directly or indirectly suggested others, maybe his supporters, to do that, focusing their ire on members of the bench. This is not news to any of you. What I'd like to know is whether before you were reached out to for a potential nomination or subsequent to outreach to you for a potential nomination, did you consider this new dynamic in the American political environment? And did you have discussions with your spouses and your families about how you would handle it if you became the target of such criticisms and or harassment or anything to that effect? Mr. Artel, we'll go down the line.
I mean, this job, I've always thought requires courage. It requires judicial courage. I think it's a quality that I have. Yeah, as I said, I've been a judge for 11 years, and I have not been shy about ruling on cases that I need to rule on. And it comes with the territory. So I understand that I may be criticized, and I'm likely to be criticized, and I was willing to take that risk because I love my country and I want to serve my country.
Thank you.
Senator, I would just add to that I do believe this is a very public-facing job, that criticism is part of it. In litigation in general, someone generally leaves unhappy with your decision, and I've accepted that, and I believe it's the responsibility of a judge to apply the law to the facts as they stand before you, regardless of the outcome that it may be. So that's what I would do moving forward if I was confirmed.
Thank you.
I agree. A judge needs to be willing, if the law requires, to issue an unpopular decision. And I think it's a great feature of our country that individuals have a First Amendment right to express, their thoughts about judicial decisions. I think that, my concern when I look at a case isn't, any criticism that might come my way. It's only, what does the law require to the case that's in front of me? And I think that anyone who takes the judicial oath needs to have the courage to do that in any case, regardless who the party is, regardless what the issue is. And that's my answer, Senator.
Senator, I agree. I think this is a tough job, and only tough people should do it. Criticism comes with the territory. My job is to follow the law and not concern myself with what someone might say and not get my feelings hurt about what they might say.
Look, I appreciate your answers. Y'all focused on criticism, willingness to be criticized comes with the territory. The times we're living in I wish it was just contained to that. Not a hypothetical. There's been instances, multiple instances, where the rhetoric is beyond just criticism. It does fall into the areas of harassment. Some suggest even threats. And I pray that none of you become victims of that, should you be fortunate enough to be confirmed. Thank you for your time.
Padilla. Senator Schiff, good timing.
Thank you. I want to follow up on the line of questioning many of us had for Mr. Bove, since you were present for that, and ask you all the same question. And Judge Artel, I'll start with you. Would it ever be appropriate for the Justice Department to take the position that they should effectively tell a district court to pound sand and ignore a court order?
Well, I just think that there are exceptions, as I indicated before. There's stays that can be pursued. There's motions for rehearing, appeals.
Yeah, that's not my question. Would it ever be appropriate for the Justice Department to tell the court, we're going to ignore your order?
I mean, Abraham Lincoln did that with the Dred Scott case. I'm
hoping we're not going to go back to the Civil War or Dred Scott. You seem to be having some hesitancy about this question. Would you have difficulty if the government ignored your order in holding them in contempt?
Senator, I would not have any difficulty enforcing any court order that I enter. Obviously, if I enter a court order, I would expect it to be followed, no matter who the party is.
Including by the Justice Department under the Trump administration?
Including the government as well, yes.
Okay. Mr. Dudek, same question.
I would expect the parties in a case before me to follow the order regardless of who they are.
Okay. Same question.
Yes, Senator. I, too, would expect orders to be followed. Of course, if I suspected that there were a problem or an issue with that, there is a process for ascertaining whether a court order has not been followed, and I would follow that process.
And that process involves an order to show cause why they shouldn't be held in contempt, and there are judges holding those hearings contemporaneous with this one. Let's say you hold that hearing and you find that the Justice Department has been in willful contempt, knowing and willful contempt. What kind of sanctions would you entertain under those circumstances?
Senator, it's hard to answer in the abstract. I know that there are a host of sanctions that can be entered on a finding of contempt. I would not hesitate to enter an appropriate sanction, whatever the case would require. I'd have to, look at the particular kind of matter, the severity and extent of the violation of the court order, and those would all be things that would be considered in such a hearing. But what I can say just as a general matter is I would expect that any lawful order that I issue with jurisdiction over the case and the parties should be followed unless or until stayed or reversed or disturbed otherwise on appeal.
Well, and building on that answer, Ms. Gaylord-Moe, let's say that the contempt involved rendering someone out of the country to a maximum security prison in violation of their right to be heard, in violation of habeas corpus. What kind of sanction would you order if you found after a hearing and an order to show cause that the government was willfully in contempt?
Senator, I'm obviously not going to comment on any pending cases, and I'm not going to weigh in on political controversies. I can tell you that the answer to your question is, do I expect the parties in a case that's pending in front of me to comply with my orders? And the answer is yes.
And you would expect that, notwithstanding the fact that they may choose to appeal or choose to disagree with your order, in the absence of a higher court judgment that stays your order, you would expect and you would indeed compel the government to comply, would you not?
As a judge, I follow the law, and I expect the parties to do the same.
Okay, that doesn't really answer my question. So in the absence of an appeal from your order, in the absence of a stay of your judgment, if the government refuses your order, would you hold them in contempt?
If the elements that would make contempt appropriate under the law were met, and I held a hearing that I felt satisfied that at the conclusion the law compelled the entry of contempt sanctions, then absolutely I would do that.
Okay, thank you. I yield back.
Thank you, Senator Schiff, and thank you so much for our nominees for being here with us today. I know people traveled far and wide to join you. That means they support you and wish all the best in your future careers. Certainly, it is an honor for me. I often take over this gavel from the chair and serve as acting chair, and it's such an honor that I got to do that today, especially as we had nominees from the great free state of Florida, and specifically nominees that I know respect the rule of law and respect if they are in fact confirmed, their Article 3 powers are limited, and that public confidence in our judiciary and the impartiality of our judiciary is incredibly important for the success and stability of our great nation. So thank you for being here today. Thank you for your testimony. Written questions for the record may be submitted until July the 2nd at 5 p.m. The hearing is adjourned.
Thank you, Senator.